I don't know. A good educational, experiential educator, I think empathy is a very important aspect. There are some injustices that a middle class Indian will not usually experience. But the next best thing is to be able to empathize, not sympathize, able to develop empathy with ethical virtue, ability to co-suffer, although it is not directed suffering. Suffering is not directed you are not the victim, but you feel the pain of the other inside yourself. Now, unless you have it, you can't be an experiencer, legal or any other kind of education. Um, and I think one important mechanism for developing empathy for teachers, not just law teachers, for every teacher, anybody involved in this type of education, is to understand the newly emerging discipline, which is called anthropology of suffering. Um, and unless you grasp the anthropology of suffering, how suffering is produced, distributed, and spread and consumed, even consumed, and what is to be done in the face of suffering. That I think is experiential education. If education, experiential education is based or is for the oppressed, the marginalized, the underclasses of Indian citizens, impoverished. So if one thing is empathy, and the second thing is not, and certainly not sympathy alone. Sympathy is important, but it is not. It's a middle class virtue. It's something that your conscience pricks for a while, and you before you get towards the thing, then kind of. The other thing for clinical experiential educator is, and this is one of the is the idea of justice, how to achieve justice for these people, and that's very difficult. But that's what the phrase, if I may say, crafting justice ideally captures. How to encraft justice, and I had a paper some time back called in Bangalore. I delivered it. It's called Enculturing Law. There's a book by that name, to which I have contributed. So how do we enculture law, and what do you mean by enculturing law? It's a vast thing, but for experiential educator, legal educator, the constitutional culture matters. And where do you find the constitutional culture? Certainly not the culture of governance, because governance ideally should find the answer to these problems. But it is busy with other things, preoccupied with security, preoccupied with order. The justice comes not as a matter of priority in governance. Development comes to us. But we find indications of what Constitution means by justice in the fundamental duties, directive principles, fundamental rights, and the preamble to the Constitution. These four things are very standard texts, but they are the heart of the Constitution. The rest of the Constitution is about how things will be done. But done for what? Done for these four things. Whether preamble, whether it is fundamental rights, duties, or something else. So that's where So that the crafting must be how to use constitutional law, the knowledges we have of these people, for the excluded people. And I think experiential education has begun with social acceleration. The whole story, I mean, how did it start? How did the Supreme Court turn around? Of course, there was emergency and there was populist catharsis and all that involved. And the Supreme Court wanted new legitimacy, and therefore you had this. It is around that time that we started writing letters. Everybody wrote letters to the Supreme Court judges. They converted the letters into writ petitions and they issued continuing amendments to discover. So originally, in the charismatic movement of new constitutionalism, this was the inspiration. So the third thing is to study how at least one major institution of the state, the Supreme Court and High Court, turned within and how they attempted to deliver justice to the marginalized. And where they succeeded, where they failed, but they tried. Can teachers of law and other disciplines begin to do that? Instead of saying judiciary is over here, there, writing law articles in defense or attacking the judiciary, which is important, it's done thing in academic circles. But more importantly is, here is a judiciary which acts as if it were a social movement, a new social movement, or the sufferings of the people. It is democratized standing. It has dispensed with procedure. It finds new facts. It invents new jurisdiction. It makes new policies. So it's amazing. Very few courts in the world have done it. So of course we criticize where they go wrong. I do criticize them very often. But at the related fourth point, namely, an experiential educationist always learns. You can't do experiential education in which the book is closed, a book of experience. Experience constantly unfolds. And therefore, we must ask whether the state institutions have learned to care. Judiciary has certainly learned to care. Has bureaucracy learned to care? We don't know the answer. We don't even know the answer, the approaches to answer. Has parliament, legislature, legislative power begun to care for excluded people? And I think this is very important. So, the last thing, I'm asked a simple short question where I'm giving a long answer. This fifth qualification of an experiential teacher, experiential knowledge is to see how state institutions have handled these experiences. It will not simply do to say that they have not handled them well. The question is not well or badly, whether they have handled. And I think they have in different fields tried to grapple with the same problem that experiential educators are grappling with. How have they done this? How have they done it? Can we learn something from it? This is the question. The 4 or 5 things that I think experiential education ought to do. There are many others, but I think these are major ones.